like Brian was just like,
Recording in progress.
and then it comes back. And
Used to take a lot of care, like taking care of the case. And then he kind of
So I would have accepted the withdrawal of the Lord. All the time, it was like humans, fighting humans. Like you could tell these guys were bored, like sitting in the symposium all day, fighting by hand. So they would draw these really graphic pictures. Snails and dogs fighting and bunnies fighting, but that's where the pythons got the killer rabbit from.
yeah. I think I'm grateful that she's actually. That she doesn't like give a fun of a teacher with I'm going to talk about the witch trials. She showed us the big clip of the witch
trials. Very quickly, just to hopefully refresh your memories, remind you, this was posted, I said this the other day, and hopefully it might ease a little, if you're feeling any sort of anxiety about any of this, hopefully this helps ease it. This document, which you don't have to submit today, is what the majority of your summative assessment grade is going to come off of. Okay, this is what I'm going to evaluate when I give you your summative grade. So if after today you realize we need to tweak this argument or that argument didn't work, you want to change that. I know it's after the fact, after the hearing, but by all means, feel free to do that and get this to me at the end of the week or whatever. All right. Your hearing itself, there's a couple purposes of it. Number one is so we can get a feel for how the Supreme Court hearing looks versus a trial, like our little Goldilocks trial. Okay. So we get a sense of how it works, the question and answer between the justices and the respondents and the petitioners. There's no witnesses, there's no real evidence presented as it is in like a criminal trial, actually, exhibit A or exhibit B. In most cases, it's the oral arguments with question and answer, and then the justices kind of act as juries to the final decision makers. All right. So the hearing today, and trust me, there's been a couple of groups that have not been prepared. That's not going to hurt them any. It's just not going to help them any. Right? What I am doing is keeping track of individuals and groups who are doing a good job answering questions with good logic and using evidence to back up their main arguments, which is to side with whoever depending upon your role in it. So in that case, your performance can boost your score on this. But this alone is what I'm going to look at. Okay, so I thought that was a fair way to tackle grading, especially the short turnaround. Not a whole lot of preparation time for this, and not to mention several groups have been dealing with absences or dealing with people in the half year, etc. All right, so that is where we're at. Okay, so your turnaround. All right, well, we will. Is there either side that wants to go? Like you're eager to just get this out of the way. Ready? Okay. You and Lauren's mathematics case, right?
No, it was a fair one.
Okay, so we'll start with this one. So if you are not a respondent or a petitioner, you are the justice. So you can sit up here. We do not have a official announcement, but that's
Yeah. You would be a little bit back out and
I'm not gonna sit back here on that. So when you are a justice, which is you three for the first case and you three for the second, this is just a little scorecard for you. This gives you a little bit of background on the case you are about. That's not the right one. This is a little scorecard. It's going to give you background on the case. It's going to show you or explain what the main constitutional questions are. If you're going to take notes on it, I'll just try to make it easier to go. And then on the back is where you make your final holding, your decision on the case. If you, depending upon time, you might not get a chance to even finish that today. That is fine. You need to kind of finish it outside.
So when I get the this thing from here,
From your back.
okay.
Yeah, I have. Because I gave you one of these already. So these cases, as we're getting situated about to start, if you all have not picked up on this by now, you know that all the cases are all pretty complex, and you can see. And I heard this from a lot of people throughout the day today, as well as yesterday, as people were working through it. You can see how you can come up with a pretty sound argument for each side of each of these cases. Okay, and that's how complex the law is. All right, because we spend a ton of time looking at what rights we have, right? Major signs, we look at side cases where you look at specific examples of cases and how they apply to amendments. All right, but what we're getting at with some of these is how sometimes those rights contradict one another, or in the real world, situation will arise where one person feels their rights are being violated, whereas the other group does not feel they are, or the other group is doing everything they can to say that, look, we haven't violated any rights, where on the surface it may appear like that. So the real world is a lot more complex than just saying, if you do this, then this will happen, or you have this right. And hopefully these cases kind of illustrate that. So, court would begin with the marshal of the Supreme Court announcing the arrival of the justices. All right. Oyez just means like here. That's where the Oyez website got its name. All right, that's how the Supreme Court is called this session. And then the Chief Justice will read the background of the case, which in some cases is a lot more extensive than others. But for the purpose of our simulation here, the petitioner will begin. Followed by the respondents. The petitioners have the opportunity to give a rebuttal following the respondents. Justices, you have the ability to ask questions at any time. I would just kind of recommend, and if you've seen actual transcripts or listened to transcripts of Supreme Court hearings, you'll see where the justices cut off the petitioners or the respondents and ask for clarification or ask leading or what if questions. I would just ask, like, let them finish their sentence. And then if you have a question, by all means, ask questions. Our first case is Students for Fair Admission versus President and Fellows of Harvard College. This case is filed in the U.S. District Court for the District of Massachusetts on November 17, 2014, by the nonprofit membership group Students for Fair Admissions. In October 2019, the judge ruled that Harvard College's admission policies did not unduly discriminate against Asian Americans and that no quotas were in place. In February of 2020, Students for Fair Admissions filed an appeal in the U.S. Court of Appeals for the Third Circuit, which also ruled in favor of Harvard. SFFA then petitioned the Supreme Court to review the First Circuit's decision. And petitioner, we will begin with.
All right. To the Chief Justice, and if it may please the court, the petitioner, Students for Fair Admissions, pleases to hold Harvard guilty for the usual acts that they have been doing in their admission process, especially the undergraduate process, where they use the rating system, which is based on personal rather than the academic system. And to us, it seems that it is very equivalent to the rating system or point system from the Scratch Bollinger case. And what we ask for the court to do so is to provide justice to the admission students who admitted and or rejected based on their racial uh, background. And yeah, that's the racial background. What we see here is the Harvard and the president and fellows of our college are violating the Title VI of the Civil Rights Act of 1964, where it specifically says that admission process cannot involve racial discrimination or any background while determining the admission of the student inside the college. And it also violates the 14th Amendment, especially the equal clause that is up in there, because race is being determined or a sole factor being used for the admission of a tribal student, and especially this leans towards the Asian Americans who have a higher academic or yeah, mostly academic achievability and skills and everything rather than personal ratings and personal characteristics. That's it. Under 2 minutes.
Questions? Um, So you referenced that Harvard has a rating system which you compare to the point system that was referenced in the Grassford Bollinger case. However, in both lower courts, they said that Harvard does not have a quota. So what are you presenting that's different? Do you have any new information that the lower courts did not, where they ruled that Harvard's system did not place quotas, it just considered race as a factor, but not the only factor?
So Harvard has considered race as the only factor when they determine their personal rating system. There is as an evidence, there is a report that has been filed up as Exhibit A, which was submitted duly to the court beforehand, and all the lower district courts as well, and the state court. Both of the courts have disregarded the report, and in the report it was an independent researcher or yeah, mostly a researcher who did this whole report analysis and all the methods, and there he says and he concludes that Harvard has used race as the sole factor, if it was the Asian American applicants who have the characteristics, that would suggest that they should receive higher ratings. That's their main soul and main role in the admission process. And then the other groups, let's say, for example, African Americans or the Hispanics, or etc., etc. This was an evidence of penalty. So using further evidence for that was the cutoff system that they had used. So if this person was, let's say, for example, me as an Asian American, I mean, indeed I am, is going to apply for Harvard, and then the backend process is that the counselor or whoever the person is reviewing the application of mine is going to go through this process. Indeed, it is true that my academics are good. So they turn down the personal rating system that is like my personal characteristics and not the essays. This is not anything about the essays that I have written before, or anything about the short response questions. It is about simply my background, where I come from, where I belong to, which race I am this particular, what is my native, what is my language, and so some factors like that. At the end of it was is that my race is considered, and then it is very similar to the quota system, very similar. I'm not saying that it's same, that's very similar to the quota system. Where, any rating that I get before I include the race as my factor, that is resulting in a cutoff. So simply what it means is that at the end of the ratings, there is 1 or 2 points added. So if I have, let's say for example, out of 36, I've got 20 points already. And now they are going to judge me on my application based on the based on the factor. What they're going to do is they're going to add just 1 or 2 points into it, and then not consider it as consider it as a fair reporting and then a fair decision. That's what Howard has been doing. And it can be seen in the exhibit E, which has been, as stated before, it has been submitted in the lower courts as well. And they did not consider it just because it was not so clear to them, especially the data tables that were very confusing to the justice system. I'm not alleging anything according to the justice system. So, yeah. Hope that answers you.
So just to really quickly clarify, are you alleging that the primary or the determining factor in Harvard's admission process is not academics or other application or other things on an application, but rather that the main factor Harvard is using in admissions is race?
So what I'm saying is that it's not about the academics. Harvard, as you know, is a very reputed college in the whole country, in the US, and they get like 40,000 to 60,000 applications, which are mostly highly academically popular, or per se maybe like they have really good academics at the end. But because of that, it's not that as the that is not the competition factor or something like that. The competition then comes up to the personal rating system that I just mentioned before in this question in there. And yes, I am saying that race is considered as the only factor we use because how it works is that at the end, after all of the other factors have been like reviewed and all of that stuff has happened, race has been considered as the like swing vote, just like the votes in the states when you have Ohio is the swing vote state or something like that. So that has been the main problem in the admission process. So indeed, yes, I'm saying that the race has been the judging factor for an applicant. So, okay, that answers the question.
But it's not the only factor.
Well, indeed, it will be the only factor being judged because at the end it's being used as a swing factor. So if I have a good point system in the beginning, then they would add a bunch of points at the end for when my race has been considered. So if I have a lower rating system already, before race has been considered, my cutoff is going to be higher. So additional points are going to be like 5 points or 6 or 7 or 10 points are going to be added. Rather than if I had higher rating already in my personal background and everything, lower points are going to be added to make it sound like more competitive. And in comparison with other groups, it's going to be more, let's say, biased, I would say.
So if you had a white student and the Asian American student, who both have the same score academically, the Asian student would get in over the white student.
They won't get in because because of how it is seen as in Harvard is that Asians are very good at academics, but not in the personal rating side. So let's say for example, in the personal ratings, I have different factors, which is let's say for example, my language, my native, where I belong from, which country I belong from. That is like the first time process. The second time process comes to BAs, which is the judging factor that I am saying. So after that has happened, or until the first process of the personal rating system has been completed, then race is being used. So I'm not sure if that answers your question furthermore, but it can be clarified at the end.
We're gonna use the time, we're gonna do respondents and
Hello, Stephen and I are representing Harvard. you to point this out, that Harvard Race Commission is still constitutional under the 14th Amendment. Now, when in precedent cases, first off, you have Robert V. Boiler, which decided that it was alright to have a race payroll as long as it is under strict judicial scrutiny and not against specific, not against people. You have also said that it is important to foster diversity, and Harvard has actually done a study that says if the race commission gets eliminated, they would actually lose significant student bodies in African American and Hispanic races.
Another one of our precedent cases is finance instructor versus Kina, which provides that, under the 14th Amendment, that it is, under strict judicial scrutiny, it is okay to, consider race as a factor to foster diversity, like you had said. Also like to point out how in Harvard, our primary sources for determining whether students get in or not is based on their academics and their backgrounds outside of race. Race is usually only a determining factor towards the very back end of that. We have nothing else to go off of. And part of that is because race can be a determining factor in like expanding on one's background just based off of either the tendencies or geographical and racial, the combination of those two factors can lead to a determination of whether the students have something outside of academics which they may have going on. And as so happens, since Asian American students that apply often go so far into their academics, it usually leaves lesser room or space outside of those academics, and so it usually turns out less full than say the white counterparts.
Now, another precedent case I want to report is on Fisher 1, which was in 2013, and Fisher 2 in 2016. Both of these cases happen, both of these cases ruled in favor of the colleges. Again, as long as there is strict judicial scrutiny, that is, and further government's interest. I'd also like to point out that we have had many evidence briefs from Harvard students, from current and former students represented by the Asian American Advancing Justice and the Lawyers Committee for Civil Rights.
So I'm understanding you correctly. Race does play a factor in Harvard admissions with the intent to foster diversity.
That is correct. We have race to foster diversity. However, again, it will come down to academics, but if you have two of the same people.
So the primary factor in admissions remains academic.
Yes.
To what if you were to give a percentage or an estimation ratio of some kind of other factors to race, what weight are they given on the selection process specifically and the quote personal rating system in particular?
I would say that the academics has the biggest percentage of determining factors. I would say that race probably comes in at, probably the third most third rating, and then the second most important one would probably just be extracurricular activities to see if they really are their leaders. If they're people who can again foster a good environment here.
You do have the final word, so if you have one final statement, you are welcome to give that out.
All right, this is this, I would just like to, refute on the point that, my counterpart, has said, especially Stephen, that race is considered as the determining factor at the end of the process, even though the applicants are still same. And how we see it as is unequal because they are compared with others. And, especially the ones with the highest rating overall cases being considered. And that is how we look at it because it's an inequality between the Asian American as an individual and then white as an individual. That's a big comparison. And what I would like to point out as well is that a group cannot determine a race group, a racial group such as an Asian American, African American, etc. Cannot determine an individual's background or reality. And oftentimes this has been considered as just because of this, that it's a group and individual, both of them can be different. An individual like me can be someone who is very studious or a lot of extra engaging in the extracurricular activities and etc. like that. But another person could be someone who is very against some of the things, very against the academics or maybe against the extracurricular activities. That's how we look at it, and it's an inequality, like I said, that it's violating the 14th Amendment, the equality clause, and Title 6 of the Civil Rights Act, just because the participating federal program that has been established in 1964, passed in 1964. The college is supposed to follow all the racial rules that have been in there that you can determine an application based on the factor of race, their background, or anything that has been the sole factor. And what Harvard has been doing with the personal rating system is very similar as the quota system. And what I would like to add on is the critical pool, applicant pool, or the pool mass is also very similar to what is in the quota system. That until they reach a really good number, let's say for example, they want 20% of whites and 20% of Asian Americans or 10% of African Americans, they would consider the applicant. And if they have not reached, if they have not reached the critical mass score, they will consider the applicant in there. But if they have reached the pool already, they will reject it. So that is how we look into it as the critical pool mass and everything. Also, and that's my end. Thank you so much.
Just one thing, really quickly. You repeatedly use the words determining factor and sole factor. So I just want to clarify once again. When you say determining factor, do you mean in the case of two applicants who are identical, except for their race, or do you mean when you say sole factor, determining factor, do you mean to imply or state that when it comes to admissions, race is considered as a factor over academics? For example, a student of one race with lower academic scores might get in over a student of another race with higher scores just on the basis of their race? Or do you mean when you say determining factor or sole factor, do you mean determining factor in the case of two academically identical or potential students?
So what we are looking for as the determining factor or sole factor is simply that, let's take an example right here so that you can better understand it. If there's one applicant who has low academic scores, but he's a white, that is going to be considered as their background, importantly, because whites are dominating the country already. They have the domination over it right now, and they have really good personal characteristics in there. And let's see another applicant who is like an Asian American like me, and who has good academics and a little bit less or more of the personal characteristics point of view. They would consider me as an not minority because I don't have a stronger group or vote inside the country And the population of Asian Americans is only about around 20% in the Harvard, what they say is it's more than that. So what we intend to see is that yes, it is being used as the personal background is being used as the determining factor, especially so there's nothing to do.
When you say that, are you trying to imply or say that Harvard is considering race over academics?
Indeed, yes.
Um, uh, so you are saying that in a situation where there is a massive gap in academic achievement, where you have uh, a 3.0 GPA versus a 4.0 GPA, or I know that GPA is below Harvard's minimum, but bear with me, you have even a full point GPA disparity. The person with that full point lower GPA could still get into Harvard over somebody with a higher GPA on the basis of race.
Yes and no, I would say that because, like I said, we use the race as the determining factor rather than the academics. Even if I had 4.0 GPA, as you said, weighted or unweighted, it is rather my background that has been used, like my family differences as well.
But is that over another student who also has a 4.0 GPA?
Yes,
Okay.
there will be some cases that can be, yes.
Okay.
Right, well done, everybody, nice job. We gotta flip, because we gotta try to squeeze this next one in. You do not have to finish your historical in your final decision yet. So I feel like that. For this one, we at least can prove to give their arguments.
Yeah, that's what the truth is.
I'm gonna judge you guys so much.
One more here. I mean, yes, if it is not
We, the next case is, Mahanoy Area School District versus, studios, after sent up cheerleading for a Snapchat message appeal to the school board, which upheld the school's decision. She then represented by her parents, sued the Mahanoy Area School District in federal court for the Middle District of Pennsylvania, which granted her preliminary injunction prohibiting the school from enforcing the suspension. The district then appealed the decision to the Middle District Court of the Circuit Court of Appeals, which upheld the prior court's decision. Mahanoy Area School District then petitioned this court, which offered a writ of cert. So at this point, petitioner, you may begin.
The petitioner, Mahanoy School District. I would like to ask you to rule in favor of the petitioner, because this case does not violate the First Amendment. He has disrupted the school environment. Additionally, we've seen in the past, the school officials have a right to prohibit students to if they place school banners or messages, and they have did that. I would like to point out that school officials are allowed to prohibit students from displaying messages that could undermine the school's missions or values. Based on Morris versus Frederick, where the Supreme Court ruled in favor of Morris, saying that school officials can prohibit students from displaying messages that promote illegal drug use. It is also held that while students do have some rights to political speech, even while in school, this right does not send messages that undermine the school's mission. In this case, the school is extending its right to regulate political speech that undermines the school values as stated in the school rules. In addition, according to the rules versus Mahanoy case, if the school does not need to tolerate a student's speech, which in our case would be is inconsistent with its basic educational mission. Also found that the staff restricted how the school could operate. In Tinker versus Synnovation, though the Supreme Court ruled in favor of Tinker, the basis of Tinker was that there are arguments that disrupt the ability in which the school could operate. In this case, BL's speech did in fact cause disruption for both the school and its peers, as many students expressed concern with BL's language. BL's policy did violate First Amendment, but it did violate the school's values and rules. In doing so, the Mahanoy school officials had every right to suspend her because she knowingly undetermined the school's message and caused disruption in how the school could operate. Thank you.
Go to them, and then we can ask questions to you.
May it please the court? I'm Joseph.
I'm Corey. We represent the respondent, yeah. Currently after failing to make her high school rescue cheer team, find it simple, not be exposed on Snapchat, and what is that with her speech? And we have this punished, therefore there is no harm and occurred off school grounds. After carefully examining the facts, you will find that the Area School District had no right to regulate our client's speech.
The commissioner is trying to make this out as if the violation or the issue was on the part of EL. However, the violation of the First Amendment was on the part of the school district. The fundamental rule of this issue is Tinker v. DeMar, which forms the backbone of protected speech in schools. In Tinker, the court found that schools could only regulate speech if it was materially and substantially interfere with the operation. The youngster does no such thing. There would be no significant interference in school environment. While Morrissey v. Frederick is based on speech happening on a school supervised event. Additionally, I'd like to point out that while Morrissey v. Frederick does seem to find in this conversation to Tinker that the school can regulate messages. The court specifically stated that was in reference to those wrong messages. I'd further like to point out that the Morrissey Frederick rule occurred at a time in which the nation was caught up in a relatively intentional panic about drugs. And Morrissey Frederick was also ruling on speech and expression that happened during a school supervised event. BL's speech and expression occurred on the school grounds over the weekend. By ruling in favor of the petitioner, you have the possibility for schools to regulate the speech of students in any context at any time, which is a vast overreach of their ability to control student speech, especially since things that occur off of school grounds, especially in this case, are often not to have a significant disruption to the functioning of school operations. Thank you.
Justices, you can pose at this point for 3 minutes, but if you want to pose questions to either side.
Okay, to the petitioner, what I'm going to ask you about the drug mentioning that you did. So what you said that drugs were being used as like the driven idea of sending or posting this thing on Snapchat. I mean, you know what has been said, I would not like to repeat it, but is that true that drugs have been the driving factor of bringing this message up?
Using in Morse versus Frederick. You mean
No.
that
I mean, yes,
it
indeed,
was
yes.
a deterring factor in Morse versus Frederick, but was not applied to my case?
In this particular case, the student made a post that was negative and against the rules for the
we can disregard the question for now. What I'm going to ask you is that these coaches who decided to take out BL from the team, did they have any kind of joint discussion about this?
I believe they did, because she also signed it was a form that said she could not disrespect any of the school, other cheerleaders, opposing team cheerleaders, any of the coaches, or any other affiliates like that. And she did violate that. Whether it was, I also that while it was online and typically all school grounds, it was still online, and about 50 people saw that. So imagine. So this might be completely the same, but I believe it's similar. If someone were to have a speech and they were promoting, or they were a student promoting values against the school in front of 250 people with the school, so the school have that.
Concerning the agreement that you signed, what were the punishments listed on violation of that?
If another situation like this, let's say a softball player, so it's kind of said the same thing, hey, performance, what would your steps be in order to punish it?
I would say I haven't talked to them, but I believe that they should be disciplined accordingly because again, they violated the school's rules, policies, and then disrespected other students and staff.
So to respond to one quick question, like you mentioned that words spoken outside of school grounds should not be, schools have no jurisdiction in disciplining a child for things posted on social media outside of school grounds. Are there any situations where they could intervene, whether it is a child that challenges another child to a fight at school the next day, or if there is drama within a certain circle of friends that then spills into the school day? Does the school have an inherent right then to intervene in something like that? If there's a potential for something like that.
In the instance that a student challenges another student to a fight over to a fight, that fight is occurring on school grounds, the school may not have the ability to intervene in their ability to challenge other students to fight. They certainly can intervene in a fight. And in the instance of something like bullying or harassment, the likelihood that all of that would occur on school grounds is close to nothing. I would also again point out that this particular form of expression was not directed specifically or intentionally at anyone at the school, and did not actually pose a direct threat or harm to anyone.
Good job, you all got a little easy compared to that first group. Well done, everybody. We will debrief a little more on Monday. We were doing attorney seats submitted to me, and you can get me your decisions at some point. I'd like to post what our final decisions were for different classes, kind of like we did with Gold Lines trial.
Another class is like lead into the other results.
The second class, we also had 3 cases. Oh yeah, that was tight. The first one was super fast, and the second case took like once people were comfortable asking questions. So I have to like put a timer down and do some practice runs, I think. But once we got into it, people did an awesome job. Have a great day, everybody.
Oh, I need to plug that on.
Yeah.